to start straight?
Yes,
Yeah.
I would go for it, yeah.
Order. Scott Benton to move the motion.
Thank you, Madam Chairman. It's a pleasure to speak under your chairmanship. I beg to move that this House has considered E-petition 607712 relating to human rights legislation reform. Over 230,000 people have signed this petition, including 283 in my own constituency of Blackpool South. It is obvious why a petition relating to human rights has been incredibly popular and has gained such widespread support. This country has always been a leading champion of human rights, democracy and freedoms internationally, and possesses a proud history stretching all the way back to the Magna Carta in 1215. This has progressed, and rightly so, to a huge number of rights across all aspects of life and society to provide people with the freedom of expression, a right to education and safety in the workplaces, among many others. However, there is increasingly a perception that the current rights culture is often contrary to common sense and flies in the face of the original purpose behind the various pieces of legislation, which in some cases has provided a platform for criminals hoping to escape punishment or to delay and frustrate natural justice. The creator of this e-petition, I'll just make some progress if I may. The creator of this e-petition stated that he did not want any changes to the Human Rights Act because he was concerned that people's human rights would be less respected. I do not believe for 1 second that this would be the case. Reforms to the Human Rights Act would bring clarity to the currently opaque human rights standards, specifically those imported and adopted from the European Convention of Human Rights. It is important to note this does not mean reduced rights for people at home. Any update to the Human Rights Act should not seek to scrap people's fundamental rights, and any update to the Human Rights Act should retain the ECHR and its original principles. But we must ensure that the Human Rights Act and its interpretations is not used to undermine the desired will of the public or that of our democratically elected Parliament.
Will the Honourable Gentleman give way?
Absolutely.
Doesn't he see any role for the protection of minority rights under the Human Rights Act and the ECHR?
Well, as I thank the Honourable Lady for her intervention. If she would wait a few moments for my speech, I will cover that in due course. But of course, all aspects of human rights should be covered within our existing provisions and protections. But it is indeed a balance between protecting those rights and allowing the government to make sure that national security issues are protected at the same time. The British people rightly believe that they should be subject to British law made by British lawmakers who they have voted for and decided upon by British judges. This government was elected in 2019 on a manifesto that promised to update the Human Rights Act to ensure that there is a proper balance between the rights of individuals on one hand and our national security and effective government on the other. And at present, absolutely.
Thank the Honourable Member for giving way. One of the aims of the bill is to prevent trivial human rights claims from wasting judges' time and taxpayer money. Does the Honourable Member agree that the Government haven't yet evidenced that this is a widespread enough issue to risk watering down the rights of citizens across the UK for nominal financial savings?
I thank the Honourable Lady for her intervention. Of course, she will be aware that this is an area the Government are actively considering at the moment. I'll be entirely honest, I wish the Government had moved ahead on this at different points over the last 12 months, but we have had consultations and things rightly have to be considered in the rounds. Clearly today we have a new Prime Minister and it will be up for him and his team to set out the new direction forward, but I'm sure those comments will be reported back by the Minister to the Department. And at present, the overreaching ECHR is tipping the balance away from national security and effective border controls in favour of serious criminals and terrorists who are abusing the current legislation to avoid their deportation. Various articles within the ECHR have been expanded beyond their original intention, In particular, what frustrates me and the residents of Blackpool the most is the expansion of Article 8, the right to respect for private and a family life, which is being used by serious criminals to make a mockery of our broken asylum system. For example, in 2020, the Strasbourg court made the controversial decision to allow a Nigerian national who was sentenced to 4 years in prison for drug offences, as well as a conviction for battery, to remain in the UK on health grounds. This has set a dangerous precedent that any state wishing to deport an individual must be able to show that the healthcare they would be entitled to in their own country would not significantly impact their life chances when compared to the NHS. Obviously, this is an unrealistically high bar to meet. In a second case, another convicted drug dealer used Article 8, the right to a family life, despite assaulting his partner and making no child maintenance contributions whatsoever. The complete and utter irony. The absurd list goes on and on. Over 70% of successful deportation appeals are now based solely on Article 8. I'll give way to the Honourable Gentleman.
By the Honourable Gentleman, I thought he said at the beginning of his speech, and I wonder if the 230,000 people who signed the petition would wonder if they were in the right debate listening to his speech. But I thought he said, which I think is the government's policy as of last week, that he wished to remain within the ambit of the European Convention on Human Rights and therefore of the court. Now he seems to be arguing against that. So where exactly is he?
Thank the Honourable Gentleman for his intervention. I'm far from a legal expert, but what I would say is there is a middle way to be had here between protecting people's fundamental human rights, enshrining the ECHR, and continuing to ensure that that is enshrined within British law, and making sure that the government has wiggle room to make sure that serious foreign national offenders can be deported and our asylum system is not overtly abused. And of course, this is the subject of the government's ongoing consultation, and I look forward to the government and indeed far more experienced legal minds than I trying to find a way through that minefield. It is my view that we cannot fix a broken asylum system until we reform the Human Rights Act. It is also my view that someone wanting to claim asylum should go through the correct procedure, of which the UK has a number of safe and legal routes. However, 28,000 people illegally crossed the Channel in small boats last year, of which 75% were male between the ages of 18 to 39. And although asylum claims should be processed within 6 months, many do not hear within that time, and the appeals process can take many years. Frankly, residents in Blackpool, my constituency, are fed up with seeing the asylum system abused and the time taken to deport those who have come here lengthening year after year. Simplifying the system and ensuring that claimants must demonstrate they have been materially disadvantaged before making a claim, as well as strengthening the emphasis put on societal impacts, such as criminal behaviour being taken into account, will help to protect our national security as well as taxpayers' money through the court system and the costs associated with accommodating and supporting asylum seekers with pending applications. The Human Rights Act received royal assent in 1998 and came into force in the year 2000, with Tony Blair's aim of incorporating the UK law into UK law the rights contained within the ECHR, which itself was drafted in 1953. After such a long period of time, the Human Rights Act would not have foreseen the incredibly complex challenges we face today. It is absolutely right that the government reviews the Human Rights Act with a focus on the modern era, whilst reinforcing the primacy of UK law and protecting the fundamental freedoms we all enjoy. Thank you.
The question is that this House has considered E-petition 607712 relating to human rights legislation reform. John Cruddas.
I've got my pen in my mouth. It's caught me there. Thank you very much indeed, Ms. Farag, and good afternoon, everyone. I want to begin by welcoming the petition and to congratulate those who organised it and signed it. It states that the proposed reform of the Human Rights Act be withdrawn. However, this demand does appear to be somewhat overtaken by events. So the first question I suppose to ask is, do the petition's objectives remain valid? Politics, as we all know, moves pretty quickly, and the proposed forms have been withdrawn. The Prime Minister ditched them, plans to erect a new Bill of Rights on the 7th of September. The papers were briefed how ministers were deeply concerned about the drafting of the bill. It was pulled just 5 days before its second reading, soon after the Justice Secretary had himself been sacked. At the time, precisely 6 weeks and 5 days ago, the Prime Minister told the Cabinet her government would reassess ways to deliver this agenda. Note that she didn't say she disagreed with the objectives of the withdrawn legislation, rather the method of their implementation. Now, fast forward to last week, 6 weeks and 2 days after taking office, and the Conservative Party has in turn reassessed the Prime Minister's own ability to deliver her own agenda and unceremoniously ditched her. So it leaves human rights reform up in the air. So the petition, is it still valid? And I think it most certainly is, because the proposed bill was in the last Conservative manifesto. It has been, as far as I can work out, in successive Conservative manifestos since 2010. Indeed, despite withdrawing the draft legislation, such a bill was supported by the present Prime Minister when she herself was Justice Secretary. And I assume that the next leader, or the new leader, I should say, and the Prime Minister unveiled this week, and their next leader in opposition, indeed, will in turn pledge to establish the legal supremacy of the UK Supreme Court, and that UK courts can disregard rulings from the ECHR. Therefore, despite the Prime Minister ditching the bill, the issues contained in the petition remain highly relevant and valid. And I think we can confidently assume that despite both party and government disintegrating before us, the party still does appear intent on reform of the Human Rights Act, maybe one of the few things that unites all the different factions in the party. Therefore, the petition's objective that the government must not, and I quote, make any changes to the Human Rights Act, especially ones that dilute people's human rights in any circumstances, make the government less accountable or reduce people's ability to make human rights claims, remains highly relevant. Despite axing the bill, these issues won't go away. They therefore deserve to be debated. Yet, generally, I'm not sure that we really acknowledge the true significance of the proposed human rights reforms. Let me give you a brief example. Seems like ages ago, but go back to the last Queen's speech on the 10th of May. At the time, the contents of the Queen's speech was widely described as a damp squib, reflecting a government that had run out of ideas, a party without a project, to quote a Guardian editorial. And I thought at the time such an interpretation was slightly wrong. Simply seeing the Queen's speech as an incoherent, aimless collection of 38 bills, symptomatic of an inert, drifting government, I thought misread what was going on. Such a misreading is important because it suggests there was little to see here and provide an alternative. This is probably the most radical element of the Queen's speech, which will be debated tomorrow, the Brexit Freedoms Bill, an extraordinary piece of legislation, the wholesale dismantling of domestic law through the constitutionally outrageous use of Sunset and Henry VIII clauses. And I thought at the time the Human Rights Bill was almost a constitutional companion piece to that piece of legislation, because acts in the Human Rights Act, if successful, would dramatically reset both our strategic international position and the rights and freedoms afforded to British citizens. And acknowledging the radical character of these initiatives in the last Queen's speech also poses many challenges and opportunities for my party in terms of what we stand for and what we would do. Not least, to put this charitably,
Member for giving way. The Scottish Government have been clear that it opposes this legislation and would invite Holyrood to oppose it too, meaning if the UK Government pushed ahead, they would be showing a disregard for devolution. Does the honourable member share the concerns of those living right across the UK that their rights are being potentially stripped away without consent?
Very much so, and I am going to come to this later when I mention different approaches to economic and social rights, which should be the cornerstone of an alternative approach to a new Bill of Rights in the UK. So I think it very much goes with the grain of what's happening in Scotland, in contrast to what the objectives are of the present government in Westminster, not least because, to put it charitably, the government's a total shambles, and even compared to early September, the possibilities of a Labour government are more likely. And it would in turn be useful to find out what Labour's approach is to the reform of the HRA. For instance, whether it would seek to defend the present Human Rights Act or offer its own alternative Bill of Rights. The Conservative reform of human rights, which will reappear, cannot be discussed without acknowledging the international context within which it occurs, set against an international backdrop of war, escalating authoritarianism. The proposed human rights reforms suggest a country withdrawing from our international obligations and democratic oversight, both abroad and at home. And this is not an accident. The government stated wish to comply with the Human Rights Convention, yet it would also seek to mandate our judges to disregard some of its most basic principles and protections. These include the so-called positive obligations on public bodies to investigate crime and wrongdoing, precisely the methods that produced remedies for the victims of the Black Cab rapist John Warboys, alongside a range of other cases providing justice for victims, most famously through the Hillsborough inquiry, and a series of cases of justice for soldiers, including that at Deep Cut. This would likely see more cases, not less, going to Strasbourg, and once again expand the power of the executive, which would be freer to rule by regulation and restrict the interpretive powers of the courts. When Europe and the world are crying out for international leadership and solidarity, our government appears to be running in the opposite direction. We might assume that it was only the likes of Russia, Poland and Hungary who cynically remained in treaties such as the Human Rights Convention whilst corroding them from within. And what I find truly extraordinary is to think that in 2023, the 75th anniversary of the Universal Declaration of Human Rights, partly crafted by British lawyers, the government planned to axe the Human Rights Act, the direct descendant of that convention that sought to unite countries following fascism, authoritarianism and genocide. Winston Churchill would arguably be turning in his grave. In his opening speech to the Congress of Europe in May 1948, he said, "The new Europe," and I quote, "must be a positive force, deriving its strength from our sense of common spiritual values. It is a dynamic expression of democratic faith based upon moral conceptions and inspired by a sense of mission. In the centre of our movement stands the idea of a charter of human rights guarded by freedom and sustained by law." 75 years on, this statement has a contemporary feel to it, as authoritarianism and fascism are once again on the march, threatening the foundations of liberal democracy. So whilst I'm glad to see that the legislation has been withdrawn, it comes with one downside. The government's withdrawn attempt to deny rights to the British people, wrapped up in an almost Orwellian language of a new Bill of Rights, did offer opportunities for opponents to build a coalition around an alternative, rather than defend simply the status quo. A radical new Bill of Rights which builds on the Human Rights Act rather than dismantles it, one that might echo themes from FDR's vision of a second Bill of Rights in 1944, which informed the Universal Declaration of Human Rights. Such an alternative might include the right to work, to free education, to access to public health, to housing, to security for all, and freedom from fear. I would like to think that this might be part of Labour rethinking its whole approach to modern citizenship, part of a radical levelling up agenda, a new democratic and economic covenant between the state and its citizens, one that is aligned with administrations in Scotland and Wales who are also seeking to build such an agenda, not only honouring the Good Friday Agreement's commitment to the Human Rights Convention, but in keeping with the long-term quest for a Bill of Rights in Northern Ireland. This offers a different type of radicalism to that of the Queen's speech and the ditched attempts to attack our human rights, and with it the desire to consolidate power within the executive and strip away access to justice. My basic point in conclusion is a simple one. The last Queen's speech was no damp squib. The reform of the Human Rights Act is a big deal that should be challenged. Thinking that there is little to see here concedes too much ground and reinforces a political groupthink that underplays the radical character of this government and its potential to isolate us, diminish our international standings, consolidate long-term economic weaknesses and enduring patterns of inequality, and hand over even greater powers to the executive. There's plenty to see here. It deserves a radical alternative. The Human Rights Act, as it currently exists, protects all of us. We lose it at our peril. It's essential that we allow us to challenge public authorities when they get it wrong, The Human Rights Act has changed many lives for the better. It must be protected and built on, and not subject to reforms that reduce its scope and limit what people can rely on it for. This debate will endure. That's why the petition before us tonight retains its significance and should be warmly welcomed. Thank you very much, Mr.
I don't wish to impose a time limit at the moment, but I will be moving to the SNP spokesperson at around 7 p.m. So Bob Neal.
Thank you very much, Ms. Garvin. It's a pleasure to serve under your chairmanship, and it's a pleasure to have the opportunity to debate this important petition. Can I perhaps start from the basic principle that the government and the Conservative Party have always remained committed firmly to our adherence to the European Convention on Human Rights. For some of us, that is absolutely non-negotiable and fundamental, and rightly so, because historically it has been very largely a British-driven instrument. British common law traditions have actually greatly developed both the Convention itself and the development of the Strasbourg Court's jurisprudence. It's worth bearing in mind that, as the Honourable Member for Dagenham and Rainham alluded to, one of the principal authors of the European Convention on Human Rights, the late Sir David Maxwell Fyfe, later Lord Kilmuir, was at the time a Conservative Member of Parliament, had been a prosecutor in the Nuremberg war trials, and later served as a Conservative Lord Chancellor. Conservative respect for human rights is actually very, very deep-rooted. And for many years, of course, the UK was a diligent member of the Convention, without having in domestic legislation the Human Rights Act. I think it was sensible to have an act which enabled the remedies available under the Convention to be sought in the domestic courts, rather than having to go directly to Strasbourg. And that was the purpose of the Human Rights Act when it was introduced. So it's not essential in terms of our commitment to human rights to have a statute in domestic law, but it is certainly convenient and greatly helps many British citizens in the assertion of their Convention rights. So I think it's right that we keep it. But does that mean it is not capable of reform? Of course not. Any legislation is capable of reform and improvement. And that was the commitment in the 2019 Conservative Party manifesto, the manifesto upon which this government was elected. And I'm happy to support that. And it was consistent with that manifesto commitment that the then Lord Chancellor and Justice Secretary, my right honourable and learned friend, the member for Swindon South, commissioned an independent review of the operation of the Act with a view to modernising and updating it. That was the manifesto commitment. No less, but also no more. And in consequence of that, the Right Honourable Sir Peter Gross, King's Counsel, a very distinguished former Lord Justice of Appeal, headed up an independent review panel which took extensive evidence, over 180-odd submissions, plus road shows around the whole of the UK, and produced a very detailed report. Subsequently, Sir Peter gave compelling evidence in support of his report, both to the Justice Committee and to the Joint Committee on Human Rights, as well, I think, also to the Constitution Committee of the other place. If there is to be reform, I would suggest that Sir Peter's report, his panel's report, is the appropriate template. That touches upon a number of practical changes that could be made. For example, the ambiguity which his panel concluded exists around the hierarchy of rights, the prioritisation of rights under Section 2 of the current Act. Strengthening the means of dealing with the margin of appreciation. That's the way in which there is a degree of flexibility consistent with the principle of subsidiarity, in which each member state of the Convention has some flexibility in the way it interprets the rights and also the enforcement of judgments and decisions according to their own domestic legal traditions. Developing the concept of judicial dialogue, which was started, again, it should be said, and brought to its current form by my right honourable and learned, Lord Clark, when he was Lord Chancellor, and then developed in the Brighton Declaration, then developed subsequently by the Copenhagen Declaration. That's a constructive means of developing jurisprudence within the member states. and also by tackling one or two other thorny practical issues around remedial orders and in relation to extraterritoriality, which is a real issue and which Sir Peter posits various alternative ways, but ultimately this House, as the legislature and the other House, would have to decide upon. So those are practical improvements and reforms. I was surprised when Sir Peter, having delivered that report, subsequently, my right honourable friend, the member for Isha and for Isha, produced a consultation document that went rather beyond the party's manifesto, and then introduced a Bill of Rights, which again went rather beyond the manifesto and rather beyond Sir Peter's panel's recommendations. Well, without reciting the history, the current Lord Chancellor in September, as has been observed, paused that legislation and wrote notifying the Justice Committee and the other relevant committees of the House that that was the position. He was right to do so, because the Bill of Rights, which has had no more than its first reading, goes beyond the manifesto commitment and goes beyond the sensible changes which I, as a Conservative, want to see, which I think is consistent with the evidence that was available to government and would, I think, needlessly undermine some of the practical workings of the Convention rights for UK citizens. Now, that's not to say that there aren't circumstances where either judgments in the Strasbourg court itself or the application of Convention rights by the domestic courts do not cause controversy and do not sometimes cause some political sensitivity, if I can put it that way. But in terms of context, it is worth remembering, and I was struck by this when I was a member of the Parliamentary Assembly of the Council of Europe, but also looking at the evidence we've had most recently, that the number of instances in which the UK finds itself in breach of its Convention obligations is absolutely trivial. We have actually one of the best records of compliance with our ECHR obligations of any of the member states. And if you look at the figures in the recent document published December 2021, it's the latest we have as yet of the report of the Joint Committee of Human Rights on how we deal with it. We've seen that the number of adverse judgments has declined from only 19 in 2011 down to 4 in 2020. There has been a consistent downward trend, and similarly the number of cases brought against the United Kingdom ongoing before the courts has declined from since 2013, 2,500 odd, down to 124. And it's worth bearing in mind that many of those cases are now historic because they related either to certain elements of retention of evidence in terrorism cases which are now dealt with, or with the prisoner voting issue in particular, where, of course, a minor amendment to the legislation resolved that issue and brought us within compliance with the Convention. So the outstanding issues, apart from those which hit the headlines around immigration and one or two other matters and asylum, are actually very minor. So when we look to change an important piece of legislation, and when we look at the strength of our commitment to our international obligation under the Convention, it's worth bearing in mind that the issues are very limited and very discreet. And that's why I hope that we will leave the current bill paused, that the government will reflect that of all the issues confronting the Ministry of Justice, there are others perhaps which are rather more pressing that we should be dealing with. And if we do move forward with reform, which I would not have any objection to, we use the evidence-based approach that Sir Peter Gross and his panel set up for us. That, I would argue to the House, is the responsible and sensible way forward, and one that completely meets our manifesto commitments. Thank you.
Joanna Cherry.
Thank you, Madam Chair. It's a pleasure to follow the Honourable and Learned Member for Bromley. I'm in a very significant measure of agreement with him, particularly about the need for evidence-based policy making. I rise to speak as Chair of the Joint Committee on Human Rights, and I remind honourable members that that is a joint committee of both the Commons and the Lords, with half of members from each, and of course it's a cross-party committee. As the committee responsible for scrutinising the government's human rights record, we have conducted 2 inquiries considering plans to reform the Human Rights Act. And during our inquiries, we've heard evidence from experts with a diverse range of views, and also from people who've benefited from using the Human Rights Act. And having considered all of that evidence, we remain of the view that we've expressed in a number of previous reports that the Human Rights Act is functioning as intended, and that it enables human rights to be enforced effectively in the United Kingdom with little need for recourse to the European Court of Human Rights. And for that reason, based on the evidence we've heard and the information we've considered, we believe that the government has failed to make the case for repealing and replacing the Human Rights Act with a Bill of Rights. So we were very pleased to have confirmation from the current Lord Chancellor that the government were looking again at the Bill of Rights bill, and that its progress would be paused while they conduct a thorough review of the bill. And we're pleased also to hear from the current Lord Chancellor that, unlike before, he intends to look at the evidence base, including the Independent Human Rights Act review. Because we were concerned, Madam Chair, about the extent or the lack of the government's engagement with experts, Parliament and the public over the Bill of Rights bill, because it followed the independent expert review of the Human Rights Act, as we've heard, and significant parliamentary engagement and inquiries and a public consultation exercise which elicited over 12,000 responses. And that's the sort of extensive engagement we should be having before we embark on reform. But engagement has to be genuine, and it has to have meaning and purpose, and those who engage should be listened to. And the Bill of Rights simply does not reflect what the government heard from Parliament's committees, from its own commissioned independent review, nor from its consultation exercise. And if you look at the government's own consultation analysis, it shows that many respondees were in favour of maintaining the status quo, maintaining the Human Rights Act, and were of the view that the changes proposed were unnecessary. But despite this lack of support, the government decided to pursue a reform which went to the length of repealing and replacing the Human Rights Act altogether. And the government's consultation analysis really provided scant to no reasoning to explain why it decided to disregard the views of a significant number of consultees. And in our opinion on the Joint Committee of Human Rights, that calls into question the integrity of the whole consultation process that preceded the Bill of Rights. And so on the Joint Committee, we concluded that given the overwhelming lack of support for these radical reforms, repealing the Human Rights Act and replacing it with the Bill of Rights was neither democratic nor necessary. And, Madam Chair, we were also particularly worried about the international implications of repealing the Human Rights Act. We were worried that the bill our primary worry was that it would, removing the Human Rights Act, would weaken protections for people living in the United Kingdom, but we were also really worried about how it would be perceived internationally. And when we recently visited the Council of Europe and the European Court of Human Rights in Strasbourg earlier this year, our concerns were highlighted, and it was emphasised to us that the Human Rights Act is viewed internationally as a gold standard and a model example of how human rights should be or can be effectively embodied into domestic law and practice. And it was really impressed on us by our interlocutors in Strasbourg that any weakening of the mechanisms in the Human Rights Act could damage the United Kingdom's reputation internationally and weaken the UK government's position when it's seeking to ensure that other states uphold their human rights obligations. We were also, Madam Chair, and this is very important, we were left in no doubt by those we spoke to in Strasbourg that the United Kingdom's status as a leading member of the Council of Europe and one of the founders of the ECHR means that any reforms to the Human Rights Act that suggest that we are wavering in our commitment to the Convention's protections could be a green light for other less committed nations to weaken their own human rights protections. Now, other honourable members this afternoon, or this evening rather, have spoken about the incredibly positive impact the Human Rights Act has had on human rights in the United Kingdom. And we've highlighted this in a number of our reports. We've highlighted that it's made it far easier for individuals to enforce their rights because they can do so in their domestic courts, and that's much cheaper and easier. Before the passing of the Human Rights Act, an individual had to take their case directly to the court in Strasbourg. And this process was subject to long delays, and by that I mean many years, and on average it cost an applicant £30,000. Another benefit of the Human Rights Act, as the Honourable Member for Bromley indicated, is it's led to a significant decrease in the number of cases brought against the UK before the Court of Human Rights in Strasbourg, because we resolve our own human rights problems at home in the domestic courts of our jurisdiction. I think the Honourable Member for Bromley gave some statistics about that. It's also, and this is contrary to what people sometimes think, having a Human Rights Act and incorporating the ECHR into the domestic law of the United Kingdom has also enabled courts, both in my own jurisdiction of Scotland and in England and Wales and Northern Ireland, to influence the development of the European Court of Human Rights case law. And we heard that there's a really strong dialogue between the UK Supreme Court and the court in Strasbourg, so that they both influence each other's jurisprudence, and that often works to the benefit of the United Kingdom. Another really important thing that the Human Rights Act has done is to embed a human rights culture in public authorities. And we heard from a number of witnesses, including an NHS Trust, the National Police Chiefs Council, and the British Association of Social Workers, that the Human Rights Act has placed human rights at the centre of decision-making in public authorities, and that the legal framework has assisted them in making complex decisions. We also heard that the Human Rights Act has been central to the devolution of justice and policing in Northern Ireland. And of course, we know it's embedded in the Good Friday Agreement. And it also plays a very important role in the constitutional underpinning of the Scottish Parliament and the Welsh Senate. And as other honourable members have indicated, in my own jurisdiction in Scotland, the Scottish Parliament has gone beyond the Human Rights Act to embed, for example, the UN Convention on the Rights of the Child. And we were very clear in the Joint Committee that we don't believe the Human Rights Act should be reformed without the consent of the devolved legislatures, because it's so important to them. Now, I want to be clear that the Joint Committee of Human Rights are not saying there should not be any amendments to the Human Rights Act, but what we would like to see is strengthened human rights protections rather than weakened human rights protections. For example, we'd like to see the right to protest, a very important aspect of the right to freedom of expression. We'd like to see that given greater protection in the Bill of Rights, and we'd also like to see the right to an effective remedy as protected by Article 13 of the ECHR. We'd like to see that embedded. And we would also like the government to give serious consideration to incorporating other international human rights treaties, such as the one I just mentioned about the rights of the child, and the Refugee Convention, including a right to seek and enjoy asylum from persecution in similar terms to Article 14 of the Universal Declaration on Human Rights. So we're pleased that the current Lord Chancellor has paused the process. We had a very positive letter from him last week. We're really looking forward to engaging with him, and we're delighted to hear that the government is going to go back and look at the independent review in a way that wasn't done before. We'll continue to engage as a committee with the government, but we have to emphasise that we believe in evidence-based policy making, and we regret that so far we see no evidence-based, we don't regret it, it's our view that so far we've seen no evidence to justify the argument that significant changes to the Human Rights Act are either necessary or desirable. Thank you, Madam Chair.
Andy Slaughter.
Savage, it's a pleasure to be here under your chairmanship, and it's a real pleasure to follow the chairs of two eminent select committees, or the eminent chairs of two select committees, the Joint Committee on Human Rights and the Justice Committee. And I think with perhaps different nuances that they were both saying very much the same thing, and so I'm not going to repeat that for a third time, which is that if there was a priority in legislation, then reform of the Human Rights Act is not it, and that is essentially what the terms of this petition say. But if, given that actually, despite that, the Honourable Member for Swindon South, when he was Lord Chancellor, did set up the Gross Review, and that was a substantial piece of work. and it was, and its recommendations were proportionate. And so, if changes are going to be made, we should perhaps be guided rather more by that than by the subsequent consultation, which paid no regard whatsoever, as far as I can see, to the Gross report. In fact, it appeared to be rather more based on a shorter piece of work, the 2009 book Assault on Liberty. The Honourable Member for Esher and Walton had read his own book again, something I have tried and failed on several occasions, rather than looking at the report which his department commissioned. And it's a shame that we've got. I would probably err on the side of not needing reform at all, because I actually think that it's a piece of legislation, the Human Rights Act, that we should be proud of, that it's actually a practical as well as a principal part of constitutional law, and it's worked very well. And I fear, therefore, that the reason this didn't start in the last year or two, it probably started over a decade ago, with using legislation like the repeal or reform of the Human Rights Act to, as part of the culture wars agenda, as part of throwing red meat to various members of the governing party. And it's in the same bracket now as tomorrow's bill on retained EU law, on flights to Rwanda, on the public order, and the curtailing of freedom of speech legislation, which we had last week. And it's a real shame that we're passing legislation of that kind, and also the motivation for passing legislation of that kind. And what it also means is we get confused. We get confused about the constitutional impact. I'll give an example, given that they're both present in the room. At the Justice questions last week, the member for Blackpool South said, asked the Minister who's replying to the debate today, the question, it's becoming pretty clear we cannot get a grip on the small boats crisis and deliver significant reform of our asylum system without reforming the Human Rights Act. What's the government's plan? And the Minister's response was, we are committed to the European Convention on Human Rights and to the UN Refugee Convention. We believe that our proposals are within the law and that no court has said otherwise. So you can't really have it both ways. Either the existing law is sufficient to do what the government is doing, or the law needs to be changed. I just feel that on many occasions that what is being put forward and argued comes out of individual cases, that results which, outcomes which individual MPs don't like, their own prejudices or what they perceive to be the views of their constituents and may in fact not be. And that's a very, very poor way to legislate. And I was pleased to see that with the, and it was very much, I think the Bill of Rights bill, it was very much an individual project in a way that's probably quite unhealthy of the right honourable member for Esher and Walton. And with his demise, that bill also saw its demise, and indeed it was described in rather brutal terms, not I think by his successor, but by Downing Street, as a complete mess, which is a bit of a harsh term to use about one of your own flagship pieces of legislation. So I think probably the best thing that could happen to that bill now is that it is quietly tucked away in a cupboard and just becomes a bit of constitutional history and never sees the light of day. And I don't know, certainly the impression from Justice questions last week, in which 3 times the Secretary of State or the Minister said very clearly that the government would wish to stay within the ambit of the European Convention and the European Court, and there seemed no urgency at all in bringing forward a replacement to the current legislation, implies that perhaps we can move on and we can quietly forget this whole rather sorry episode. I noticed on the library page relating to today's debate, it says of the bill, its fate is unclear. Well, perhaps it should remain unclear and we could all move on to perhaps more important things. It isn't as if the MOJ doesn't have other...
Order. The sitting is suspended for 15 minutes for petition in the House. See you in a bit. See you shortly. Remember my pulse. Order. The sitting is resumed. The debate may now continue until 7:53. Call Andy Slaughter.
Thank you very much, and that's a welcome respite from my speech for members of the committee. Gives me a hint not to go on too long. I was just saying, as we were interrupted by the bell, that really this shouldn't be a priority for the government. I think the Minister knows, having had time now to study his brief, and maybe he'll even be there tomorrow, who knows, that with some of the worst backlogs in the criminal courts, and indeed in the civil courts, with a real crisis of confidence in the justice system, a real crisis in access to justice, and particularly in legal aid, which the government concedes to some extent by the reviews it is undertaking or is undertaking in the case of the civil legal aid review. There is more than enough for he and his colleagues to do without looking for work and without interfering with legislation that is working well. In a way, the government is in a favourable position now. It has the excuse to move on and quietly forget the bee in the bonnet that the honourable member for Easter and Walton had, or if it wishes to follow the lead of the chair of the Justice Committee and go back and look again, it has a really fine report by Sir Peter Gross and his colleagues. It doesn't really need to go any further than that. I'm not going to go through this in depth because I don't see any point of that till we know what the government's bringing forward. But it did make you weep to see the way that the Human Rights Act was misconstrued, whether it was about parliamentary sovereignty, whether it's about the margin of appreciation. The proposed reforms, particularly sections 2 and 3 of the Act, really distorted both the purpose and effect of the Act and the way it was working. I think it was thought to be, and constitutional legislation is a very difficult thing to get right, it was thought to be a success and something which effectively made the conduct of justice easier because it brought human rights down to a domestic level. It gave direct access to the UK courts, and it meant that justice could be obtainable at a lower cost, more speedily, and in a more relevant way. All of that happened, and the only thing that's being reversed, because the government has said it's not going to take us out of the European Convention, we will still be subject to the judgments of the European Court. It will just take much longer, be a much more protracted process to get there. How can that be in the interest of justice or the interest of the individual citizen? As my old friend for Dagenham said, this is not about lawyers, it's not about highfalutin principles, it's about the ability of individual citizens in important areas of law and decisions which fundamentally affect their everyday lives to challenge the state and to challenge institutions when they get that wrong. What is obnoxious about that? That is the role that the Human Rights Act performs. That's the role it can continue to perform, with or without the sort of amendments we've talked about today. To repeal it as an act of sort of political bravado is simply irresponsible, and I do urge the Minister away from that course. I would like to think we can hear from him today a little bit more. I'm not hopeful because of what the Secretary of State has already said, that he will take his time, but at least a little bit about the direction of travel and where the government thinks we should be going on this. I think that would be a helpful outcome to this debate, and the almost 250,000 people who have urged upon him caution, I think would be pleased to hear that message is being heeded in the Ministry of Justice.
Jim Shannon.
Thank you, Madam Chair, and it's a pleasure to serve under your chairship as well. Can I also thank the honourable member for Blackpool South for the petition presentation. I have to say that I'm very much in favour of retaining the Human Rights Act as it is. I know that the Honourable Lady for Edinburgh South East referred to there might be a need to do some tweaking or some changes, and I'm not against that idea, providing we have a chance to discuss that and see what they are. But I'm very much of the opinion, Madam Chair, to have the Human Rights Act retained as it is. I'd like to start by thanking all of those 230,000 people who signed the online petition to stop reform of the Human Rights Act. The almost 250,000 people who voiced their objection to human rights being diluted in any circumstance, I believe, reflects the views of possibly millions more. Certainly those who I'm speaking to and my constituents want to see things left as they are. These people oppose moves to make the government less accountable. They support increased ability for people in need to make human rights claims, and I think that there's a need to have that option, that opportunity within the law as it is. For context, and just to give an idea of what 230,000 people are, it's twice the population of even the largest constituency. It is 1 in 8 voters in Northern Ireland. Northern Ireland is 2 million people. This isn't a fringe issue. It's a massive issue. The correspondence I'm getting on it, Madam Chair, tells me that they are deeply concerned about this. In fact, as a general rule, people want more human rights safeguards in place, not fewer. And with a third of the United Kingdom believing that the United Kingdom government is not doing enough to promote human rights abroad. And I want to, perhaps, for the Minister, and I'm very pleased to see the Minister in this place, and I want to make some comments about human rights and abroad, and my, as I chair, as everyone knows, I chair the E-petition for freedom of religious belief, and I am a deep and strong believer when it comes to making trade deals with any country in the world, key to that must be human rights. And the right of liberty to serve and worship your God as you wish to do. I know government's committed to that, I understand that, but I want to put that on the record as well. With a third of the UK believing that the UK is not doing enough to promote human rights abroad, I think the government is quite active, but people are telling me this. Almost 3/4 of the British public agrees the UK should take into consideration human rights standards of a country when negotiating or signing a deal with it. And over half of the United Kingdom of Great Britain and Northern Ireland agree that the amount of foreign aid given to a country should be tied to that country's performance on human rights standards. I totally and fully support this condition. I know the government, in all the debates I have and the questions I ask of the ministers who have direct responsibility for different parts of the world, I am quite encouraged by what happens in relation to that. It would seem, therefore, that if this government, my government, were to reform human rights, they should make standards higher, which might be the issue of doing it, let's do it better, rather than watering it down. And if that's what the Honourable Lady is saying, I think it is, by the way, then that's exactly what I would be saying as well. Rather than making legislation more manageable for this government's own economic or trade interests. Human Rights Watch submitted to the Joint Committee on Human Rights the view that a repeal of the Human Rights Act would, and I quote, weaken human rights protections and send a negative sign globally about the value of international human rights and the worth the UK government attaches to them. I'm sure the Minister, and I'm quite confident of this, doesn't want that to be the opinion of those who look from the outside in towards the United Kingdom. I think many will agree with me that this is a scathing assessment of the impact that any repeal could have, and perhaps a rightfully scathing assessment on its own, never mind anything else. Globally, human rights have never been under greater threat. Putin's war in Ukraine, we know all the things that are happening there, and every one of us is dismayed, disgusted and angered with it, and our government and our ministers have taken strong action in relation to that. Protests in Iran, I mean, Madam Chair, we all watched the protests right across Iran, and all the villages, towns and cities are there. Ladies more often to the fore in the protests. They're the ones who are feeling the brunt of it more. Over 400 killed, and most of them women and children, and almost 20,000 arrested. All looking for freedom, for liberty, for human rights, which we support. China's treatment of the Hong Kong people, the Hong Kongers, I suppose, not just in Hong Kong, but in Manchester, as we witnessed there the week before last. I mean, it gives an indication of, when it comes to human rights, that in this country we want to see human rights as well as we do in Hong Kong as well. The bombings of schools in Afghanistan, human rights abuses. It is really quite annoying. They've all made the headlines in just the last month. So if we are to continue, Madam Chair, continue as a global champion of human rights, we cannot let that message be lost by what we do at home. And always what we do here is so important. Other learned, right honourable members have made some fantastic contributions. I endorse all of them, many with a greater knowledge than I have. In my capacity as chair of the APPG for international freedom of religion and belief. I am frequently in dialogue with civil society and government representatives from countries where freedom of religious belief is a major concern. In the talks with all these groups across the world, it is the UK, our UK, United Kingdom of Great Britain and Northern Ireland, leading influence in defence of human rights that makes bilateral accountability possible, and it does. So it's critical and it's vitally important. It would be my concern, as well as many others, that replacing the Human Rights Act with a Bill of Rights would send to these countries that the UK does not practice what it preaches. That's the interpretation will come out of that, in my opinion. And I'm quite sure the Minister will respond in a positive way and lay that to bed. And that it does not care for human rights as an absolute good in themselves, but only as a means to an end. Such transparency of selfish interests would inevitably undermine attempts to promote human rights abroad. It would do far more harm than good. So I suggest, in conclusion, Madam Chair, to leave the Human Rights Act as it is. There are many in the United Kingdom of Great Britain and many more across this great world that we have a duty to protect. Human Rights Act, not a Bill of Rights. If there's going to be changes, make it better. Dilution of present provisions in place, I cannot and will not agree to. Madam Chair, thank you.
Stephen Bonner.
It's a pleasure to see you in the chair today, and I commend the member for Blackpool South for moving the motion on this petition debate for us today. And we have heard a very good debate, and it's clear that this is an issue close to the hearts of many of our constituents across the 4 nations. And we heard today from the honourable and learned member for Edinburgh South West. She is always such an authority on these matters, and it's always worth noting all she has to say as the joint chair of the Cross-House Committee on Human Rights. And we also heard from the member from Strangford. We are often on opposing sides of many of the debates and divisions of this place, but I have to say I fully agree with everything that the member for Strangford has said here today. And also thanks to the learned and member for Bromley and Chislehurst. And I thank the member for Dagenham and Rainham also for his excellent contributions, and of course the member for Hammersmith and for his interrupted contributions. I'm glad to say that none of the points he was making have been diluted. Political bravado indeed. And I would also like to place on record my thanks to the public who have partaken in their democratic right and signed E-petition 607712, including 326 from my constituency in Coatbridge, Christon and Belsill. And I'm very grateful for the opportunity to speak on what can only be described as an unashamed attempted power grab by this government in the form of its proposed reform to the Human Rights Act. There is absolutely no justification for such reform at this time other than this government creating for themselves the potential to put itself above the law. Such is this UK government's desire to substantially harden an already hard Brexit. They are literally ripping out the final piece of European-related legislation that we have before us. But it is not a piece of legislation that could nor should be changed lightly, if indeed even changed at all. The Human Rights Act, as it exists currently, aims to protect every individual across our society, and we lose that at our peril. It is an essential law that has allowed us to challenge public authorities when they get it wrong, and this has helped secure justice on issues from the rights to life to the right of freedom of speech. The Human Rights Act has changed many lives for the better. It must be protected and not subject to reform that reduce its scope or limit when people can rely upon it. This reform is a threat to how and when we can challenge those in power, including stripping some people's rights away and requiring a person to have permission from a judge before they can even take a state to court. The UK government must respect the rule of law. This change will mean future UK governments of all political leanings will be beyond the reach of public accountability. Where is the democracy in that? The utter contempt of the UK Tory government in upholding human rights has been blatant for us all to see in their attempts to send refugees, some of the most vulnerable people in our society, to Rwanda. In the time that this scheme was invented, public pressure and the protection of our current legal system has meant that not one refugee has been sent on a plane. And yet, ironically enough, we are on our third Home Secretary in that same time frame. And I suppose that's not that surprising when you caveat it with that we are also on our 4th Chancellor and we now today have our 3rd Prime Minister in such a short space of time. I think the government should be focusing on far more important things than tinkering with human rights legislation. But it was the words of that Home Secretary, the Right Honourable Member for Fareham, and I have alerted her that I would be speaking, I found to be the most chilling. It was her dream to see planes of refugees sent to Rwanda. Of all the dreams to have. Surely the outcry from that statement, Madam Chair, is of no greater example of how the Conservative Party interpretation of human rights protections is starkly different to that of the wider public and indeed the constituents of members across this hall. One of the most concerning elements of the reform for my constituents in Coatbridge, Christen and Belsill is implications on the integrity of the devolutionary settlement, and we've heard encroachments into that from members already today. The Scottish Government, along with other devolved governments, have been abundantly clear that they do not support any such reforms, and it would infringe upon eroding the very rights that years of devolution has thus far achieved. A report published in July 21 by the Joint Committee on Human Rights concluded that, quote-unquote, the Government should not pursue reform of the HRA without the consent of the Scottish Parliament. Well, that consent has not been given. The Tories in their Bill of Rights say they want to strengthen the country's proud traditions of freedom, curtail abuses of the human rights system and reinforce the democratic prerogatives of MPs over the legislative process and respect to human rights. It takes some serious neck, Madam Chair, for this Government to portray itself as coming to the defence of judges when it has been at constant war with them over the judgments that they have given that this Government do not like. Tory proposals to uphold citizens' rights simply do not equate with the legislative reality passed under this UK Government, like the Policing Bill, the Judicial Review Bill, the Nationality and Borders Bill, the Elections Bill and now the Public Order Bill, all of which impede on the rights of our citizens. The UK Government must stop all attempts at rewriting the Constitution and devolved settlements whenever they choose to do so. Such practices cannot continue, and Scotland does not accept this manner of working. I implore the UK Government to stop all attempts to reform the Human Rights Act legislation and fully support the aims of this petition and the petitioners. Thank you.
Lee Reeves.
Thank you, Ms Vervagen. It's a pleasure to serve under your chairship. The strength of feeling on this issue has been demonstrated not only by the near 250,000 people who've signed this petition, but also the speeches that we have heard today. The Honourable Member for Dagenham and Rainham talked about the Human Rights Act providing justice for victims, including Hillsborough, soldiers, women facing violence. The Honourable Member for Hammersmith and Fulham talked about this being completely the wrong priority for the justice system and his hope that it will now be abandoned with the demise of the previous Justice Secretary. And the Honourable Member for Strangford shared his commitment to the Human Rights Act and noted that the very large number of people that have signed this petition and the strength of feeling on the issue. So the case has been made very strongly about why the Human Rights Act has been such an important piece of legislation and why under no circumstances should it be scrapped and replaced with the government's draft Bill of Rights. It's with relief that the government didn't bring forward this bill for second reading last month. And I hope that today the Minister will confirm that this bill will not be coming back and that they'll be dropping their attempts to scrap the Human Rights Act. Because make no mistake, rather than a so-called Bill of Rights, this was a rights removal bill designed to dilute the rule of law and weaken the rights of British citizens. The Human Rights Act was brought in by a Labour government with a simple but profound aim: to bring rights home, ensure human rights protections are accessible, and to provide a mechanism to hold the executive to account. And for the last 25 years, the Act has met this aim. Indeed, the Act is recognised around the world and has been integral to the union of our nations. As has been said, the Scottish Government consistently made it clear its support for the Act in their response to the Government's Bill of Rights consultation. The Welsh Government has recorded its opposition to any proposal to replace the Human Rights Act. And perhaps most significant of all, the Act has played a large role for peace in Northern Ireland, because full incorporation of the European Convention in domestic law was a key aspect of the Good Friday Agreement in 1998. I know, and members across the House would have grave concerns about introducing legislation that could undermine the Union. And in the debate today, we've talked about the importance of evidence. The member for Bromley and Chislehurst has called for the need for any review to be evidence-led, and the member for Edinburgh South West has said that the Joint Committee on Human Rights completed 2 cross-party reports concluding that the Human Rights Act is working well and doesn't need to be repealed or replaced. This was also the conclusion of the independent expert review, and also the review of well over 250 charities, trade unions and human rights organisations that joined together calling for the protection of the Act. Organisations working with vulnerable people, ranging from the charity Action FGM to Mind, to the Chronic Illness Inclusion Project, Down Syndrome Association and Southall Black Sisters, have also expressed that the Act is a proportionate and well-drafted protection for our fundamental liberties. The evidence is that the Human Rights Act is working, and is overwhelming. And far from the mythical rights cultures the Conservatives point the finger at, the Human Rights Act time and time again has been the course of redress for those failed by the state. Take Corporal Anne-Marie Element. After she reported being raped by 2 Royal Military Police officers, she suffered bullying, ostracism and overwork. In the end, she took her own life. Using the positive obligations under Article 2, the right to life, Anne-Marie's family secured a fresh inquest into her death and a new rape investigation. The results of these investigations led to improvements in military justice system that have helped support service people who have been victims of rape and sexual assault in the ministry. It also led to the formation of the Service Complaints Ombudsman, an independent body that investigates complaints by service personnel. The positive obligations under Article 2 also ensured that bereaved families of the Manchester Arena attack in 2017 and the Fishmonger Hall attack in 2021 received full investigations. These examined whether the attacks could have been prevented, and the lessons learned were placed on counter-terror operatives to better protect people in the future. The Human Rights Act is also an essential tool for upholding women's rights to live free from violence through the positive obligations under the Act. But the Conservatives' Rights Removal Bill would remove these, therefore limiting women's ability to challenge the state's failures to protect them. A prime example of positive obligations under the Human Rights Act in protecting women is in the case of black cab rapist John Warboys, which my honourable friend, the member for Dagenham and Raynham, has also spoken about. Despite 2 of his earliest victims reporting their experiences to the police, systematic failures to properly investigate or take these reports seriously meant he was not charged and was free to continue attacking women for many years. But thanks to the Human Rights Act, those victims are able to take the police to court and hold them responsible. More recently, the High Court judgment regarding the policing of the Clapham Common Vigil for Sarah Everard saw the Act play a crucial role when a court ruled the Met had failed to understand the law when they banned women from holding a vigil for Sarah. Thanks to the Human Rights Act, the organisers were able to seek redress. It's unconscionable that the government are pursuing an agenda which would attack these basic rights, and I hope the Minister will confirm that this legislation won't come back. So in conclusion, rather than looking to the genuine positives of the Human Rights Act, in the legislation that was proposed, the government have attempted to dismiss it as a law misused and exploited by criminals and extremists. But the truth is that the Act offers essential daily protections for citizens that in so many cases we take for granted. There is no justifiable reason for the government to try and curb these obligations on the state to protect our human rights. It simply seeks to absolve the state of responsibility. Unless the Minister today is willing to accept the importance of the Human Rights Act and commit to dropping their Bill of Rights, then I'm afraid it just adds to their score sheet of not being on the side of victims, not being serious about tackling violence against women and girls, and not being a guardian of the rule of law. Labour, on the other hand, believes in a country that is accountable, that has proper checks and balances, where institutions seek to protect the rights of the people they serve rather than cover up and obfuscate when things go wrong. That is what we aspire to, and that is why a Labour government would defend the Human Rights Act.
Thank you very much, Mrs Fofana. It's obviously a pleasure to serve under your chairmanship, and if I may, I start with a number of thank yous. Can I thank the contributions that have been made by the Honourable Member for Dagenham and Rainham, and also the Honourable Member for Hammersmith, Strangford, also the contribution from Member for Edinburgh South West, and Coatbridge, Christon and Bellshill. I apologise if I've got that slightly incorrect. Also Bromley and Chislehurst as well, and of course the Honourable Member for Blackpool South, who is bringing this on behalf of the Petitions Committee. And can I also thank the creator of this petition, who I understand is in the public gallery. I thank him for his engagement with Parliament, and I hope that he will agree that this has been a very constructive debate that we have had. There may be slight differences of opinion, but I think it's been a very positive thing that we've had. So I also should thank the Honourable Member for Lewisham West and Penge. I like the people of Lewisham West. When I stood there in 2005, I found out that I like them rather more than they like me, actually. But that's a separate issue. It's a wonderful constituency that you represent, and thank you for your contribution. I'm grateful genuinely for this debate to come before Westminster Hall, because it gives me an opportunity of setting out the government's position on this particular issue, because the UK has had a long and proud history of recognising and standing up for the fundamental human rights of individuals. Robust protection of these rights, such as the rights to freedom of thought and freedom of expression, is a vital cornerstone of our modern democracy. It is in recognition of this fact that the government pledged in our manifesto to review and update the Human Rights Act. It's review and update the Human Rights Act. The Human Rights Act was created in 1998, as we've heard, to give further effect in domestic UK law to the rights set out in the European Convention on Human Rights. Almost a quarter of a century has now passed since that Act came into force, and in that time it has occupied an important position in the UK's human rights framework. After over 20 years, it's entirely right that we should now look again at the Act and seek to update it, not with the intention to reduce the protection of our rights and freedoms, but to make sure that this country's human rights framework continues to be the best that it can be, meets the needs of society it serves, and remains a leading example on the international stage. We want to ensure, Mr. Fofana, that the Human Rights Act strikes the proper balance between the rights of individuals on the one hand and our vital national security and effective government on the other. The government established the Independent Human Rights Act Review in December 2020 to examine the framework of the Human Rights Act in terms of how it is operating in practice and whether any change is required. Chaired by the ex-Court of Appeal Judge Sir Peter Gross, who the member for Bromley and Chislehurst alluded to earlier, the panel was tasked with considering the relationship between domestic courts and the European Court of Human Rights and the impact of the Human Rights Act on the relationship between the judiciary, the executive and the legislature. The panel's report was published in December 2021. The government is most grateful to Sir Peter and his panel for their valuable report. Following this, Mrs Fofana, the government commenced work on a Bill of Rights. As well as taking into account the report from the independent review, the government's reform programme has also considered wider issues relating to our domestic framework. These wider issues included striking a balance between individual rights and the wider public interest, and giving public authorities confidence to carry out their duties. The bill's progress through Parliament was paused in light of a wider review of policy priorities, as you would expect when a new government is formed. We are taking this opportunity to closely consider our approach to updating the Human Rights Act and to ensure that the provisions we put forward will deliver the government's objectives as effectively as possible. Let me be clear that throughout this process, any reform to the Human Rights Act will be fully in compliance with the European Convention on Human Rights, as well as with the UK's other international obligations, including the Belfast Good Friday Agreement, Northern Ireland Protocol, and our trade and cooperation agreement with the European Union. More broadly, Mrs Vervaag, we will maintain our leading role in the promotion and protection of human rights, democracy and the rule of law internationally. The UK's record at the European Court of Human Rights demonstrates our commitment to ensuring human rights are protected. The UK's human rights record is strong. Out of all the states parties to the European Convention on Human Rights, the UK has the fewest applications to the court per million inhabitants. And I have figures that are slightly different to the member for Bromley and Chislehurst, but I think the point still remains exactly the same, because at the end of 2021, applications against the UK made up only 0.17% of the court's ongoing caseload. And there are very few final judgments of the courts that find violations by the UK. 2 in 2020 and 5 in 2021. More broadly, Mrs Vervaag, we will maintain our leading role in the promotion and protection of human rights, democracy and the rule of law internationally. For instance, we of course continue to be a strong supporter of the work carried out by the United Nations treaty bodies in upholding the broader human rights system. The UK remains a strong advocate of the United Nations Human Rights Council, and we have a deep commitment to the success of its universal periodic review. We believe that it is an important mechanism of universal and constructive peer review. It allows the sharing of best practice and promotes the continual improvement of human rights on the ground, and is therefore a process we will continue to engage with. The UK has been praised in the UN's previous Universal Periodic Review dialogues for our leadership on certain recommendations and our commitment to the review process. We have recently published our state report for our 4th Universal Periodic Review, the dialogue of which is scheduled for November 2022. This petition rightly points out that the Human Rights Act provides important protection, and whilst that is a sentiment with which I could not disagree, it does not preclude us from looking carefully at how it could be improved. Updating, yes, of course.
Or if it ain't broke, don't fix it. And he's used the phrase review and update himself, so I assume we will have no more of repeal and replace, which is what it says in section 1.1 of the bill that's paused. He said quite rightly that we both are a contributor to international human rights and we are less criticised than many other countries in that respect. Aren't these just all arguments for not needing any comprehensive review? 20 years is not a long time. Magna Carta's been around for about 800 and something. We're not talking about repealing that.
Let me be absolutely clear. The Conservative Party manifesto at the last general election made it very, very clear that we wanted to review and update the Human Rights Act. We would still remain compliant with the United Nations Convention on Human Rights, whatever changes that have been made. And so it is purely to review and update. The manifesto does not say that we wish to repeal and scrap the Human Rights Act. Yes, sir.
He's been very generous. And he's making reference to manifesto pledges and his commitment to delivering them. And I wonder, is it only his government that's allowed to deliver on the manifesto pledges? Because the Scottish Government has a clear manifesto pledge to deliver an independence referendum. Self-determination does come under a human right, and I wonder why he would like to deny that to the people of Scotland.
I think that might take us down a rabbit hole that I think you might regard as being out of order. I think the honourable gentleman will know that the Human Rights Act is not a devolved matter. It is a matter that is retained by the United Kingdom Parliament to legislate upon. So, if I may conclude, unless there's any further interventions, Mrs Favard, updating the Act to ensure that it serves its intended purpose and that it keeps up with the needs of a changing society is a crucial step towards doing just that. The work to review how to best achieve this is continuing, but I look forward to updating the House in future on that. But I can reassure everyone here today that protecting the rights and freedoms currently enjoyed in this country will remain of utmost importance throughout this process.
Got Benton to wind up.
Thank you, Mrs Favard, and also to those members who have spoken in this afternoon's debate, particularly thoughtful contributions from all of those who have spoken, the members for Dagenham and Rainham, Bromley and Chislehurst, Edinburgh South West, Hammersmith and Strangford, as well as all the front benches, of course. It's a particularly opportune time for this debate at the moment with the incoming new Prime Minister. Tomorrow, I'm sure the Department will establish a way forward and the Minister will feed back all of the shades of different opinions from today's debate as the Department establishes a new way forward. We've alluded to our manifesto commitment to review and update, and I'm very reassured by the Minister's comments in terms of that it's still on track. Of course, we are now in the second half of the Parliament, so the sooner this comes forward, the better, and I look forward, along with other backbench colleagues, to seeing what the government does produce and how this can safeguard people's rights whilst allowing us to reform our immigration system and ensure that those who are a threat to national security can be deported at the same time. A difficult circle to square, but I have every faith that the Minister and his team can achieve this. So thank you, Mrs Favard. I'm happy to close the debate.
The question is that this House has considered E-petition 607712 relating to human rights legislation reform. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. Order, order. The sitting stands adjourned.
The proceeding has ended. 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 Live.tv. ParliamentLive.tv. 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 ParliamentLive.tv.